Hello, I'd like to welcome you all to our Tuesday 1:30 p.m. session with Lisa from Legal Counsel for the Elderly once again, where she'll be talking about life planning and potentially some public benefits as well today. So again, thank you so much for joining us. The WildTech DC Senior Digital Inclusion Program, its owners and presenters offer technical assistance, virtual health, well-being information designed for educational purposes only. You should not rely on the info and any apps or topics made by WildTech, including but not limited to mobile device applications and any social media pages maintained by WildTech, its owners or presenters as a substitute for professional medical advice, diagnosis, treatment, or legal advice. Thank you so much for letting me read the disclaimer. If you cannot see us, hear us, let us know in the chat, etc. Let's make sure to keep our TVs and cell phones in mind. And as always, make sure you take notes and or screenshots so you can review the information for later, but this will be on YouTube. So hello, YouTube. And you can review and rewind as much as you'd like. Lisa, if you could introduce yourself and your topic for today, thank you so much. And then we can get started.
Okay, have hello to everyone, and I'm trying to say happy Tuesday to you. I am a staff attorney at Legal Counsel for the Elderly, and I'm going to be discussing what we call life planning, which is basically estate planning, wills, powers of attorney, a little bit about trust, which a lot of people seem to have questions about, transfer on death deeds and guardianships as well. So as I mentioned, feel free to jump in during the presentation. That's fine. I will see your hand raised. I think Alex will help me with that as well. I'm going to try to share my screen. Let's see. Okay.
What?
Okay. So I'm going to start the presentation. And again, I am from Legal Counsel for the Elderly. I'm staff attorney there. I work in the Economic and Healthcare Security Group, where I work specifically with individuals who are homebound and who are either have difficulty leaving their homes or in assisted living or hospital setting. However, there are attorneys who work with people who are able to come into our office and do the same thing. They work with life planning documents, which which is what I'm going to go through. I'm going to tell you a little bit about other areas that Legal Counsel for the Elderly helps with, and you may be very familiar with that, so I won't spend a whole lot of time on that. As you probably know, Legal Counsel for the Elderly helps people with free legal and social work services, trying to empower those who need it. Legal Counsel for the Elderly is in its 50th year. We address the most important aspects of older adults' lives, including housing, economic security, self-determination, and health and safety. We impact the lives of nearly 10,000 people annually while advocating for city reforms in laws, regulations, and long-term care facilities. So as I mentioned, some of the areas are housing, so tenants' rights, economic security, having to do with benefits rights and public benefits, self-determination, which is what we're going to be discussing, health and safety, and advocacy. Okay, to start with the presentation, this chart here shows different ways people are able to assist us with our decision making, going from a less restrictive to more restrictive. On the more restrictive side is a guardianship. So, say if I became incapacitated, I was unable to appoint somebody to help me, a court would be responsible for doing that. And that process and that authority would be called a guardian. So, a guardian would be appointed for me, either somebody who I know or the court will appoint somebody who is registered with the court and willing to do that, or a conservator, which, if I had many assets, including a home, then a conservator might be necessary. A representative payee is somebody who can collect government funds for us. Substitute healthcare decision maker is an agent who will make decisions regarding our healthcare if we are not able to. Powers of attorney, which is what I'm going to go into more depth. And then there's something called supported decision making. Supported decision making is one where the individual who's getting it done retains the authority to make their own decisions, but they have assistance from somebody. So it might be the person doesn't lack capacity, they are able to make decisions, but they need assistance gathering research information, maybe talking to the doctors. So that's a less restrictive one because the individual maintains the ability to make their own decisions. Okay, that is also true for a financial power of attorney. The individual who's getting it done maintains the ability to make financial and legal decisions for themselves as long as they're able to do so. So if I was to get a financial power of attorney done today, I could appoint my daughter to be my agent. At the time that I do that, I have capacity because I'm only able to execute this document if I have the ability to understand the document. Okay. So I appoint somebody and I say, she can assist me by doing a number of things, right? She can write checks for me. She can make legal decisions. She can come to court for me. She can enter into contracts for me. That's what a financial power of attorney allows. There is a choice when you're getting a financial power of attorney. You can make it effective immediately, or you can say at some future date it will be effective. So, for instance, if I knew I was going to go out of the country, I might say I want a financial power of attorney to be effective for the 2 months that I am out of the country. Okay. And then once I'm back, after the 2 months expires, it's no longer in effect. Or I might say, I want it to be effective only if I become incapacitated. I lose the ability to make financial decisions for myself. And if that happens, then I want my agent to be able to step in and do things for me. The reason people get a financial power of attorney done is because we never know when we might lose capacity, right? And so if we proactively get this document in place, then somebody is there prepared to be able to take on this role. If we don't, then we could fall into the position where the court has to appoint a guardian or a conservator for us. A power of attorney can be broad, can allow for the agent to have broad powers, which means that the agent can do almost anything that the principal can do. So if I'm getting a power of attorney done, I'm the principal, and I can say that my agent can sell my property and can enter into contracts, go to the bank and withdraw money, deposit money, they could do almost, just about what I can do for myself. That would be broad powers. On the other hand, the powers could be limited so that I could say, I do want to have an agent to help me with financial and legal matters, but I don't want this agent to be able to sell my property. I don't want them to be able to make any loans on my behalf or to give out any gifts that I don't authorize. So that would be a way of limiting the powers of the agent. Okay. Um,
If there are any questions, again, please raise your hand in Zoom. I again, I put Legal Counsel for the Elderly's hotline number in the chat. If you have any specific questions, either after this call, it's in the chat as well. Please raise your hand if you have any questions.
Thank you. Okay, a financial.
Oh, we have
Okay.
a question. Yvonne, thank you.
Thank you, Alex. Lisa, does one have to file this with some legal entities such as the Legal Counsel for the Elderly to make it, to put it into effect? Do you have to file it, or is it okay to just document the papers and give it to the person you recommend or choose as the power of attorney?
Yep, great question. So a financial power of attorney doesn't need to be filed anywhere. So it's like it doesn't need to be filed with the court. But what most people will do is give a copy to their bank, for instance. So that way, if the agent comes to the bank already has on file. It's been given to them by the principal. That this individual, who obviously will have to show their ID and so forth, but this person is the agent. But you don't have to file it with any particular agency or organization for it to be effective. Yes, you give a copy to your agent when the time comes, or let your agent know where the document is. And then when they need it, so for instance, suppose the agent needed to reach an agency regarding your retirement, then they could just provide a copy of the document to whoever they are dealing with, as long as they have the copy. So that's a good question. I hope I answered it for you. A financial power of attorney is void once a person dies. And so just to focus on this a little bit, because this is a question that I get a lot about, when does the power of attorney, become ineffective, right? It is only effective when the principal is living. And once a person dies, then it becomes void. So, at that point, once a person died, there are other documents that come into play, so a will or a trust, but the financial power of attorney is again only effective while the principal is living. The principal can change or revoke the document at any time. And that's important to know. It's not set in stone. If I have a agent appointed for me, and I find that I start to lose confidence in that person. I don't believe they're the right person to be my agent. Then I can always change it, or I can decide I no longer want a power of attorney, and I just have to do that in writing. All right. In DC, a power of attorney needs to be notarized. So the principal will sign the document in front of a notary, and a notary will then sign, saying that they're notarizing the person's signature. You can have witnesses as well as a notary, but in DC it's not required. Sometimes the question comes up, can I have more than one agent or co-agents? And the answer to that is yes. So I have 3 children, and sometimes people may think, for different reasons, they may not want to have any of their children feel left out, so they decide to have more than one, even 3 or even 4 people acting as agents for them. And they might say, if it's 2, well, they'll have to agree. The only way they can do anything is if the 2 come to an agreement. If there's more than 2, they may say the majority will control. So if I had all 3 of my children as co-agents, then as long as 2 of them agree on an action, like selling something for me, for my benefit, they're selling a piece of property because I need the funds for my care. As long as 2 of them agree, then they'll be able to do it. We generally don't, having co-agents can be complicated, but everybody knows their own situation. It may be that the 2 or more people are able to work together well, and there may be a good reason to do it. But it does complicate things, right? So if there's something that I need and I have multiple agents, it may delay the time when what I need can get done, because the multiple agents have to be contacted, they have to confer, and they have to agree, right? You can also put in a power of attorney if there was some reason that a guardian needs to be appointed. This is who I want to be appointed. This person who I have as my agent, I wouldn't want them to be my guardian. People can sign with an X or initials in DC, and sometimes signing can become an issue if there's some loss of sight or for some other reason. I mentioned representative payees, and that is a device used by the federal government that does not accept a general power of attorney or accepting, funds. So like if your retirement funds or some benefits that you receive from the federal government, if you wanted to have somebody accept those funds, they would be a representative payee. The government would not accept just a regular financial power of attorney for that purpose. However, I would say it's a good idea to have both representative payee and also a general financial power of attorney, because while the federal government doesn't accept it, other institutions do accept a general power of attorney. Okay, I'm going to move on to healthcare powers of attorney.
Any questions, please raise your hand. Are there any other questions so far? You can unmute yourself as well. Any other questions about financial powers of attorney?
Okay. All right, so a healthcare power of attorney, very similar to a financial power of attorney, but different focus. Here we're talking about somebody who can help make healthcare decisions for us. And I mentioned when I talked about the financial that there's this choice you can make. You can make it effective immediately or upon your incapacity. For healthcare power of attorney, differently, you don't have that choice. It is only if you are unable to make your own healthcare decision that an agent's power will come into play, right? So if I'm able to make my own decision, then health professionals should do what I tell them that I want and should not look to my agent. But if I lose the ability to make my decision, now my agent, whom I have chosen, will be able to make decisions for me. The kind of decision that a healthcare agent can make is if I need a second opinion, right? If they believe that a second opinion would benefit me, if I should be transferred to another facility, or what kind of home care I need. Those are the kind of decisions an agent can make for us. Like the financial, a healthcare power of attorney is void once the principal dies, and it too can be changed or revoked as long as it's in writing. In DC, a healthcare power of attorney must be signed in the presence of two witnesses. And so there's a little difference there. A notary is not required for the healthcare power of attorney, but not a bad idea. Okay, but two witnesses are required. Okay. A part, I don't know whether there's a question in the chat or not. If there is, let me know.
That was just me sharing the to raise their hand if they have any questions.
Okay, all right. So another part of the healthcare power of attorney is called a living will or an advanced medical directive. So this can be a separate document, or it can be part of the healthcare power of attorney. Often in a hospital setting, they will refer to this as a DNR, do not resuscitate order. And so this is about end of life decision making, right? So let's just say I am in a coma, and two doctors say they confirm that I'm not likely to be able to come out of the coma. I'm going to remain in that state. Okay. Prior to then, I could execute this advanced medical directive and say what I want to happen if I ever get in that position, right? I can say, if I'm in that position, I don't want any life-sustaining treatment. I don't want to be resuscitated. I don't want to have nutrition or hydration. I just want to be kept comfortable. I just want to have pain relief. But other than that, I don't want any life-sustaining treatment. That's one option, right? And another option is that I want all levels of life-sustaining treatment that are possible, right? If even if I have to stay in that state, I want to be given treatment, right? And then people can break it down into, there may be something in between that. You may say, if it turns out that after some period of time goes by and I'm still in a vegetative state, I choose to stop getting life-sustaining treatment after X amount of time. Okay, though that's an option. Another thing that people can do is to say, I don't want to make this type of decision ahead of time. I would rather my healthcare agent make the decision, because they are going to be the ones, discussing my condition with the medical professionals. Whereas, I may have made the decision 10 years ago, and this decision I made 10 years ago is coming into play, but my healthcare agent is right there at the time when I'm in this condition. I'd rather they're in a better position to make the decision. So some people make that choice. And as you probably know, people have had all kinds of experiences. So sometimes people have experienced, somebody being kept in a certain condition for a long time. And so they know that they don't want that to happen to them. And so they might make the decision based on that. Organ donation is something else that one can decide whether or not you want to be an organ donor, or you specifically want to state, I am not an organ donor. Or again, leave that decision up to your agent. Right, so that is medical powers of attorney.
Any questions from the group? Yes, take a second. Any questions about medical power of attorney? Do you mind going back a slide, Lisa? Thank you again. Yes, living will, advanced medical directives. Any questions? Please raise your hand. Okay. You got Mr. Tom. Thank you for joining. You have a question for Lisa? Make sure you hit unmute in the middle. Mm-hmm.
With regard to organ donations, make sure that people know that they should contact the recipient just as soon as death is near or anticipated, or certainly if a person has just died. There are time limitations depending on the donations as to when they can receive an organ from a dead person. A stale, somebody who's been dead for days or sometimes even hours, it's too late to make the donation because the organ is no longer usable. And even if you're donating not for a donation reuse, but just for medical purposes and educational purposes, they also have time limitations. So making sure it's on the records, and that you are proactive in letting the recipients know that the person has died. It's extremely important with regard to donations of parts or all of the body.
Thank you. Thank you for that.
Thank you, Mr. Tom. We had Infinite Legacy come on our sessions before, so if anyone's more interested in that, please check that out on our YouTube channel. Thank you so much. Hi, Ms. Doris. You have a living will, advanced medical directive question?
No, I just want to thank Tom for what he was saying, because I was not aware of that. And when my brother passed, I was emotionally upset about him being, leaving us. And I got very irritated that people was calling me before I could finish grieving, right away. I didn't know it was a time limit. So I thank him for giving me that information.
Oh, yes. Again, check out that Infinite Legacy video on our YouTube channel.
Okay, thank you.
Mm-hmm. My pleasure. Any other questions about advanced medical directives, living will? You can unmute yourself as well. Any other questions? Okay, I think it's time for the most.
Okay. So the documents that I talked about earlier, financial medical powers of attorney, are done, with you and maybe an attorney, or however you happen to get the document done. It does not include a professional individual like a doctor. Okay. This document, the medical orders for scope of treatment, is one that allows you to make healthcare choices in consultation with your doctor. So, in this case, both the principal and the doctor will sign the document. Presumably, the principal will have talked about the document with their doctor. And this document, unlike the other one, will be registered with the Department of Health. And it can be done along with a healthcare power of attorney. And again, it can be changed like the others. But in this case, if it's changed, it'll be both the principal and the doctor both will have to make a change to the document. Okay, those are all the incapacity documents, and now I'm going to move on to the last will and testament. So again, just let me know if anything comes to mind while we're going through this part of the presentation.
Yeah, yes, please raise your hand in Zoom if you have a question. I'm looking.
So as we all know, a last will and testament allows the individual, the person who's getting it done, I'm going to call the principal again, to put in writing who they want their assets, personal property, real property to go to. And, you know, it may not be a home, but it could be something else. It could be some instructions. It could be, some family heirloom or, something that is significant to the individual. Sometimes people ask about whether or not, does it make sense to get a will done because, for instance, I don't have a big estate to leave, so does it make sense? But I think we're all pretty familiar with instances where families have had big disagreements about things that maybe not worth a whole lot in terms of money, but maybe for some reason special to the family. And if there's no instruction left, it can cause a lot of tension and problems within the family. So last will and testament is a good idea, I think. In addition to putting in writing what should go to whom, and the principal is also appointing a personal representative or executor, either of those terms might be used, who is responsible for making sure of what your desires are that are stated in the will are carried out, right? Make sure that the property is distributed properly, that any bills or taxes are taken care of. So that's going to be, somebody who you think can handle that type of responsibility. A will can be changed or revoked at any time before death, right? You can, somebody could just actually write, revoke on the document. They could, it's not something where you make it and now you don't have any choices. You can amend it, you can totally modify it altogether, you can revoke it at any time, as long as you have the capacity to do so. Okay, I see a hand. Yvonne. You're on mute, Yvonne.
Oh, thank you. Yvonne, you have a question?
Yes, thank you so much. I'd like for Lisa to mention some of the language required by law, and also if a last will and testament has to be registered with an agency of the DC government. Is that a requirement? And is a notary or anything of that nature required? But I wanted the language required by law particularly.
Yeah. So
Thank you.
Oh, absolutely. One of the main things that needs to be included is that the person who is the principal who's getting the will done is of sound mind, right? So that's a statement that should be included in the will, to say I'm not being, you know, I'm not being coerced. I know what I'm doing. I'm of sound mind. Um, the will, and they're not a whole. There may be another requirement that I'm not thinking of, and it might be actually part of this presentation. But there are not a lot of written requirements, right? You have to sign the document, and obviously it has to be in writing. It does not have to be in front of a notary. It should be now these rules change from jurisdiction to jurisdiction. So what I'm talking about is in DC. It doesn't need to be notarized, but it should be signed by two witnesses, right? And sometimes people will have a notary get it signed, sign it also. And one reason for that is in the event that the witnesses can't be found, maybe can't understand their writing, so it may be difficult to get in touch with those witnesses 20 years from now. So some people will have a notary also, but it's not required by law. With regards to whether or not it needs to be filed, right now, DC does not allow the filing of a will prior to death, but that law has just changed last year, so that people will be able to file their will prior to death, I think starting in next year, in 2027. Before that, I think DC said they didn't have the capacity to hold on to all of the wills. People might relocate, and so they did not want to basically store those wills. And so right now, still, people have to wait until the death of the loved one to file the will. But when things change, because they've updated that, and I think it's in 2027, you'll be able to get your will done and then file it with the court. And so people won't have to try to find an original. The court will only accept an original, so you'll know that they have the original that they need because it's filed. All right, so I hope I answered your questions.
Yvonne, if you have another question, please raise your hand. Again, we have Ms. Doris for a question. Thank you.
I have a question. Suppose you have a parent and they had property and they passed and they didn't have a will. And the kids is taking care of the property since the person passed.
Yeah.
How do you deal with that?
Yeah, that's a good question. So, if somebody passes without a will, then their property will go through intestate law. So depending if they were in DC, then it will follow that jurisdiction, DC's laws about how the property is to be distributed. So if you have a will, you can say I'm leaving all of this property to my youngest child, right? You can do that. But if you don't have a will, then if we're talking about, I think you're talking about land or home,
I'm
then
talking about a house,
house.
and the person passed, but they did not have a will, but they have children that's still taking care of the property, and the person been dead like 4 years now.
Yeah.
And
So
they still paying the gas bills and all that. Nobody's in the house.
right. So land, homes pass, again by intestate, but if they're children, so their parents and they have
Yeah,
children.
they children, and the property is paid for.
Okay, so that property will be equally distributed amongst the children, so they have an equal interest in that property. Um, as long as they continue to pay the taxes and the bills, they're good. They can always decide to update the deed that's probably in the parent's name. They can update the deed. They could decide, that one of them wants to buy the others out. They could do that. But in answer to your question, the ownership will go um, based on the intestate law. So in this case, each of the children would have an equal ownership in the property.
Okay, well, there's no problem with that, but they having a problem through probate to deal with trying to finish off the house because none of them want to live in there.
Yeah.
All of them agree to whatever it says on the house. So I'm trying to figure out where they supposed to go to get help.
Would that be a legal Counsel for the Elderly hotline question, Lisa?
Yes. Yes. We
Okay, because the person was a elderly person that passed, and they've been gone about like 4 years, and only two of the children is paying the utility, keeping the property up or whatever.
Is the property in DC?
Yes.
Okay. Yeah. So legal counsel for the elderly does have a probate division. Uh,
Okay.
and so if you take the hotline number, you can share it, and our hotline division
In the
will.
chat.
Oh yeah, I have the number.
Mm-hmm. Mm-hmm.
Thank you very much for that. Cause they just paying out money and nobody's in the house, and they've been going through this for 4 years, and they've been getting to run around with probate.
Wow. Okay. Yeah. Yeah.
Thank you very much. I appreciate the information.
Absolutely.
Thank
Absolutely.
you for the question, Miss Doris.
Mhm.
Any other questions about Lest Will and Testament? You can raise your hand in Zoom or unmute yourself. Any other questions? Okay, Yvonne, you have another question. Thank you.
Yeah,
And
I
then
was just
your
wondering.
points.
Thank you. Lisa mentioned the court. Would that be DC Superior Court, or what court would that be?
So there is a probate court in DC. So it's very close to the Superior Court, but it's a different building. It's a probate court.
I see it. It's a separate structure,
Yes. Mm-hmm.
probate court. Oh, thank you. Thank you, Alex.
Oh, thank you, Yvonne. Again, as a reminder, make sure you check out the hotline number in the chat. Most of us should be aware. And just any specific questions, if you make sure you utilize them. We have Denise, thank you, and then Gracie.
Hello, how are
Mhm.
you? I had a question. My dad, I'm his only child, and he was married to a lady, and they lived in Maryland, and he took sick. He had COPD, and you know how that is. Sometimes, the oxygen, leaving your brain, so you start, doing little things and different things, and so anyway, make a long story short, his wife said that when he got, real sick, he said that he wanted to be cremated, and she said it's in the will, but I never heard my dad say that. But she said, yeah, and I am too. And my dad always told me he wanted us to have dinner or something so he could read the will. And so when he passed, you know, I never still got a chance because I was telling her why he was real sick. Like I say, well, what is the will saying? She said, oh, we get to that later. This ain't time for that. We'll talk about that later. And I say, because if you saying that's what he said, but I don't know. I mean, but when you married, you don't have control of that person at that time. So she said, yeah. So when he passed, she asked me to do his funeral, the money that he did give me. And she said, because he don't have no money, I had no money. blah blah blah, whatever. So I paid for it. So okay, that's cool. But I was saying why I never still did never see that will, because everything he had, she did something else with it. His cars, his clothes, his jewelry, his train set, different things he had. I never got anything. So when my question is, can I still be able to read that will as someone, because it's in Maryland?
Yeah. Yeah. So you I'm going to say a couple things. One is that we don't, we don't deal with Maryland, but
Right.
we do give referrals to attorneys and including attorneys in Maryland. Okay. And there
Mm-hmm.
might be a legal services organization that
Mm-hmm.
can assist you in Maryland with that. You certainly should be able to see a copy of the will. I believe I'm not really familiar with the law in Maryland, but I
Mm-hmm.
think you should be. And also, wills are public documents. So if the will was um, filed with the court
Uh-huh.
wherever he lived, if it was filed, you can just check the court and see if it was filed. You can get a
Mm-hmm.
copy of it because it's a public document.
Mm-hmm.
Um, Now, if she didn't file it, then that's, you'll have to get some help to get assistance. And the other thing to keep in mind is that children from children of a deceased who are not the children of the spouse are generally, um, if there was no will, let's say, or if the original of the will couldn't be found, then the children would be entitled to something. Um, and the only way they wouldn't is if there was a will, and it left everything to the spouse or somebody else. But I
Mm-hmm.
would look into it and see.
Yeah, because I'm just going by what she's telling me, but you're still not showing me the will, lady. Although I have his ashes here with me now, but you know, it was just it just seemed like something was hidden.
Yeah,
Because why you still haven't let me see the will?
yeah,
So I don't even really talk with her now, but I was just trying to ask you, how do I go by if I still want to,
yeah,
just to read it, just to see what because I'm his only child,
yeah.
I think I
We'll
had a right
look
to do that.
and see if they can give you a referral.
Okay. All right. Okay. Well, thank you so much
You're welcome.
for that help.
Thank you, Denise.
Mm-hmm.
You got Gracie. You have a last will testament question?
Yes. Um, I,
Hello.
I, I did a will and I got the two witnesses. And one of the persons that was in there, they asked me, could they have what I was leaving them? And I gave it to them. I just crossed out given to that person. Would that stand up, as being okay for me to do that, or should I rewrite it?
Yeah, you should rewrite it
Mm-hmm.
because any changes that you make should be like part of, there should be witnesses to that too,
Oh,
right?
okay.
So, yeah, I would just rewrite it and have your witnesses again, notarize. And then, or you could just do, if you don't want to rewrite the whole thing, you could just make an amendment to it. So you just do a one pager. This is an amendment to this will from this date. And you're changing this part of it because, that was given, their inheritance was given to them already.
Okay. All right. Thank you. And one other question. How can you avoid probate court?
Yeah, good question. So there are different ways to avoid probate, and
Hmm.
um, I'm going to I'm going to turn to,
Yeah,
let's see.
you talk about it in the presentation.
Yeah, yeah, yeah. So
There's so
I'll
many
get to
good
that.
reasons for that. There's
Yeah,
so many good
I'll
reasons.
get to that. And I'm going to, let me just check here. Okay. All right. So and then as I go through that, if you have a follow-up question, just let me know.
Okay.
Okay. So reasons for a will, I think that's self-evident to let people know what it is that you want. And this slide here is an example of what I was talking about regarding intestate succession. So if there is no will, then DC has decided who would be entitled to anything that you leave behind. So just to give a couple of examples of this, I'm not going to go through the whole thing, but if you died and you had a spouse and you had children from that spouse, the spouse would get 100% of what you leave behind. Okay. Um, on the other hand, if you have a spouse and you have children who are not from that spouse, then the the spouse would not get 100%, right? So it may be 2/3 to the spouse, and 1/3 to the children. Okay. This just so you have in mind that there's a specific plan that the government has if you don't have a will, right? And that plan might not be what you want, so that's why it's a good idea to have a will. Last one I'll say, if you had both spouse and parents, 3/4 would go to the spouse, 1/4 to your parents. Okay. I will just mention this one, and I think this is kind of written funny the way it is here, but what it's saying is that the law doesn't distinguish between children, from a marriage or not from a marriage. So if somebody dies without a will, all of their children would be considered their descendants and beneficiaries, would be entitled to a part of what's left, regardless of whether, let's say, 3 of the children were from the marriage of the decedent, and 2 were from before the decedent got married. It wouldn't matter. All the children would be treated the same. Okay. Now, to get to the question, our last question, how to transfer property outside of probate, okay, which is a very good idea. And you may be familiar with the fact that probate can take a long time. I think one of our questions included that as an example, that probate had been dragging on. It can be costly. It's public, and most people want to avoid it. So one way of doing so is if there is land or a house involved, you can use a transfer on death deed. Transfer on death deed works the way a POD of a bank account works. So, in a bank account, you can say, I'm the only owner of my account. I'm not going to add my children to my bank account and make them co-owners. But upon my death, they will be the beneficiaries. So your bank can do that for you. For land, you can do the same thing. You have a deed that says, yes, I'm the owner of my property. I can do anything I want to with my property. I can sell it. I can refinance it. But upon my death, this is the beneficiary. Okay. If that, which is coming up, but I'll just say now that you can, if you do that, if you use a transfer on death deed, you can update it. You can decide to change it or make it void or whatever. But it is a very good and efficient way to avoid probate. Life insurance, um, retirement accounts, these instruments have beneficiaries. So they're not subject to probate. A testamentary trust is a trust that's formed inside of a will, but the type of trust most people are familiar with is a living will or a revocable will. And that can be structured in such a way to avoid probate. And that's the main purpose of those trusts, is to avoid probate. Um, I won't go into detail about this, but just to say, if you do decide to transfer property using a transfer on death deed, it needs to be recorded at the office of the recorder of deeds. And it's only effective upon the death of the individual. And I think enough said about these ways to avoid probate. Okay. Life insurance, bank accounts, the living trust. I'll just say how a living trust works. A person, let's just say I decide to form a trust. What I'm doing is I am making a contract to say that I want to include some assets that will transfer according to what I have in the trust. And because I put those assets, I changed the title of them. So, for instance, my bank account. Right now, my bank account is in my name, Lisa Brown. If I get a trust, then I will change the title of my bank account, from my name to the name of the trust. Really, it would be Lisa Brown, trustee of the Brown Family Trust. Okay. So still in my name, because I'm the trustee of my trust while I'm living. So Lisa Brown, trustee of the Brown Family Trust. That's now my bank account is titled that way. Because it's titled that way, when I die, now it doesn't need to be closed like a regular bank account, would be if I died. I didn't have a trust and I didn't have a beneficiary in my bank account. If the bank finds out that I died, they are going to close my account because they don't want somebody who's not entitled to do so to get in and get those funds, right? They're going to wait till the probate process starts. But if I have that trust, the trust says, once I die, this is the trustee. Now, this is the owner of that account. It can all be done without the need for probate. And so that's how that works. It's kind of, you have to sometimes you have to hear that a couple times, but that is the way it works. There are tax credits for real property in DC. One of them that Legal Counsel for the Elderly assists with is called Schedule H, or the DC Real Property Tax Credit for homeowners and renters. Eligible DC residents can qualify for a certain amount per year tax credit, and they can apply for up to, going backwards, 3 years, and get that tax credit if they qualify. Okay. So along with the housing, consumer, other areas that legal counsel assists with, these wills, powers of attorney, transfer on death deed are things that we help with. And I know you already have our hotline number, but there it is. And if anybody else has any questions about anything that I presented, or the last part of it, please let me know.
Oh, thank you, Lisa. We really appreciate your presentation today. Please stay on it so we can look through the slides if we need to. But are there any overarching questions about anything covered today? Any questions? You can raise your hand. You can unmute yourself. Any questions for Lisa? If you have any specific questions, please call their legal hotline, That's again an option we welcome you to, as we always do when we have legal counsel. Any other questions? But I really love the questions during the session. Any questions? Okay, I see you, Louise. 1 second, okay? We have a question in the chat. Is it best to have a will and a trust?
Good question. So if you have a trust, you will most likely have an accompanying will. That will has a particular purpose. It's called a pour over will. And the purpose is in the event that you neglect to put an asset in your trust, right? Sometimes people, you may hear this, people get a trust done. And then the second step is to put those assets in the name of the trust, right? But sometimes people are so, they've gone through a lot with getting the trust done and they forget that second step. They don't put the assets in the trust. Okay, if that happens, that pour over will that goes along with the trust will tell the court, I have a trust. I didn't put my assets in the trust like I was supposed to, or it might be just one asset I forgot to put in. But I do have a trust. They, my executor trustees, they don't have to go through probate. Just pour that asset over into my trust. So if you have a trust, you will have that type of will that goes along with it. A trust is a good idea. Some people feel that they don't need a trust, they only need a will because they have taken those steps that we talked about earlier to avoid probate. They have beneficiaries on their bank accounts, they have a transfer on death deed, they have a life insurance with beneficiaries. And so, as far as they know, unless something happens, like if they get into an accident and there's a settlement and they're unconscious, there's funds they didn't prepare for. But if that doesn't happen, as far as they know, they've taken the steps to avoid probate and therefore they don't need a trust. Trust is one more thing to say about a trust, though, is that it is applicable while a person is living. Like if you become incapacitated, your trustee can step in and do things with those assets. So it kind of depends on individual circumstance, which one is best. But there are advantages to having a trust. It is also much more expensive than just getting a will. And so it is a good idea to figure out whether or not it is something that is needed.
Thank you, Lisa. If the whoever shared that question would like to ask another one, then that is okay as well. I think I seen we had Louise. You have a question for Lisa today? Thank you so much.
When you sign the trust, it says my commission expires a certain time. Is that important? Do you have to go do a signing again or revise it?
I have to say that I love these high quality questions. They've all been great questions. Well, that about the commission is regarding the notary. And no, you don't have to do that as long as the notary's commission was valid at the time when they signed it. You're good. You're good. You don't have to.
No, it's still good. And there was one more thing. I had my mom on my trust, but she passed. Do I have to revise that part?
The only reason you would need to do that is if you did not have a backup person. If you have a backup person, then that's the way they're supposed to be designed so that you don't have to go in and make changes because of something like that.
Yeah, because it's understandable that she already passed. So whatever it was doesn't add up now. It's not necessary.
As long as you have a backup person, you account for that in the trust, which most likely is accounted for, then you're good.
Thank you.
You're welcome.
Thank you, Louise.
You're welcome.
Miss Hill, did you have a question? I thought I saw you unmute yourself, but Miss Hill, did you have a question for Lisa today?
Yes.
Thank you. We can hear you.
I wanted to know if it was possible a will. I saw a will, but my sisters wouldn't send me a copy. So I drafted a letter and I'm gonna send it to her and ask for a copy. And if she doesn't give me a copy of the will that had my name on it, can she be forced to give me a copy?
Yes.
It's in another state, in Chicago, Illinois.
Okay. And of course, this type of law is specific to the state, right? So, but generally, if you are a beneficiary, if you're then my guess is that you would be entitled to a copy of the will. That only makes sense, right? But so I don't want to speak for the law in that state, in that location, but I will say that you most likely will be entitled to a copy of the will because you have your own interest to make sure that what was in the will was carried out. Also, remember that um, whoever the executor is may have filed the will with the court, so you may be able to get a copy from the court.
Okay, thank you.
You're welcome.
Thank you, Miss Hill. Please call legal counsel if you have any other questions.
Thank you so much.
Of course, during this call too, but just everyone utilize legal counsel for the elderly. They're there. Not every place in the US, the country has something like legal counsel, so please take advantage. Another good question in the chat. Does the trust prevent probate for property? So that makes me think of the transfer on death deed or the living will.
Right. So, um, when someone has a trust um, done for them, it includes usually, and you want to look for this, that the deed is updated. Um, So it can be updated in one of two ways. One is using the transfer on death deed. Another way of updating it would be to put the property ownership in the name of the trust, the way I described, like a bank account. Instead of just my name, it's Lisa Brown, trustee of the trust. You can do that with the deed also, so that the deed would be the owner now. The grantee would be, in my case, Lisa Brown, the trustee of the Brown Family Trust. That's the owner of the trust. And then what that means is that once I'm gone, I'm no longer the trustee. Whoever is the trustee now takes over. So that avoids probate. You can avoid. So if you have a trust, you should have the deed updated in one of those two ways, and then that would avoid probate.
Thank you for answering that. Yeah, oh, yes, thank you for asking, Ms. Taji, appreciate it. And
Let me just mention that legal counsel does not do trust, okay, but we can refer you to somebody. We do wills and the other documents that I talked about, the powers of attorney.
Any other questions for Lisa before we almost end for the day? You can unmute yourself, raise your hand. Any last questions for Lisa today? Any last questions? I knew it was quite a bit of information, but Lisa, you did a good job of just going over the basics and kind of building upon each slide. So thank you so much for that.
Absolutely.
hmm You're not
Glad-
alone. You're not alone in this. You got to call and have, get that helping hand. All right. Well, Lisa, any thoughts on our the questions? How you think the session went today? Anything to look out for? But thank you again from Legal Counsel. Always does an amazing job. We had such great turnout today.
Oh, great. It was a great audience, and I am glad that I was able to be here. I'm glad that it was interactive. I think you all got good information because of your questions, and it was a pleasure for me to spend this time with you.
Thank you, Lisa. Again, hotline is 202-434-2120. I always share folks should just call and do a public benefits check-in. I remember that amazing session that Robin did, just making sure you get the most out of the benefits you are getting. So I always just recommend you call legal counsel for that. But any other hot topics or hot things that folks can call the legal counsel for, especially, it's January is like tax season's coming up, and so a lot of these things may be coming up as folks take a look at that. Anything to look out for, Lisa?
Nope, I think we're good.
Hmm. Awesome. Well, we hope to see you once again with Robin or with Emily, who did an amazing job for us as well. But we hope to see you again and to keep us updated on anything, any changes. But I see a lot of very informatives and thank yous in the chat, and I must agree. So let's all thank Lisa for a wonderful job today and wishing her great and rest of her week. Thank you,
Thank
Lisa.
you,
Thank
Lisa.
you, Lisa.
Amazing
Thank you,
job.
Lisa.
Thank
Thank
you.
Thank you
Thank
so
you,
much.
Lisa.
Excuse me. Thank you,
Thank
Lisa.
you.
Thank you so much.
Thank you
you.
so much.